Is my screen by any chance visible?
No, ma'am, it's not yet.
It is not yet. I do not know what the problem is. I think even after going through so many technological changes, some of us are technologically challenged, and I'm one of them. In case it doesn't work from this system, I'll join from the other system and then present it from there. So let me join from the other system so I can present it to you there.
Is there some issue?
Actually, Ms. Shweta Bharti couldn't share her screen, so she has switched laptops. So she'll be joining in sometime.
Just give me one moment. I have joined from the other screen. I wanted to share my screen
Okay,
there.
so there is some issue in Shweta. Okay.
Yeah, can you see my screen now?
Yes.
Right. So this is, the list of dates and how it goes. So 1990, this company was incorporated, the company that we call MBL Infrastructure. This company was incorporated in 1990, and this is the respondent company. Between 1990 to 2010, this company availed of loans and credit facilities from the respondent number one, which was by the respondent number one from the consortium of banks. So there were different banks who were involved in this transaction. So he availed of, or rather they availed of the loans and credit facilities from different banks. Now, 2013, on the failure of the respondent number one to act in terms with the repayment plan, some of the respondents were forced to invoke the personal guarantees which were extended by the respondent number three for the credit facilities which were availed by the respondent number one. So two proceedings were in fact invoked under section 13 subsection 2 of the SARFAESI. One was done by the RBL Bank and second was done by the State Bank of India. So RBL Bank thereafter filed a petition under Section 7 of the IBC. So it did not continue with the SARFACI, rather filed a Section 7 before the NCLT Kolkata to initiate the CIRP process against the respondent number 1. Now, this was admitted by the order of 30th March 2017, and the Honorable NCLT Kolkata appointed an interim resolution professional, which led to imposition of moratorium in terms of Section 14 of the Code. So after the moratorium was imposed and after the expiry of the initial period of CIRP, an application was filed by the resolution professional for extending the duration of CIRP by an additional 90 days, which was also granted. Now, in this process, 2 resolution plans were received by the IRP. One was authored by the respondent number 3, who is the promoter of the corporate debtor, on 29th June 2017. Now, this was done prior to the introduction of Section 29A to the IBC. So a series of meetings took place with the active participation of the Committee of Creditors on the resolution plan, which was submitted by the respondent number 3. And a decision was made in the 9th meeting of the COC, which sought an appropriate resolution plan at the hands of respondent number 3. Respondent number 3 is the promoter. So in tune with the aforesaid directive, the respondent number 3 had submitted a modified resolution plan in November of 2017. Now, by way of IBC amendment ordinance, so the day he has submitted the modified resolution plan, that is 22nd November 2017, 23rd November 2017, which is another very important day. On this date, by way of an Insolvency and Bankruptcy Code Amendment Ordinance 2017, Section 29A was introduced. Now, it is in this context that the COC had held its meeting on 1st of December to deliberate upon the impact of the amendment qua the eligibility of the respondent number 3 in submitting the resolution plan in the CIRP proceedings. So December 2017, because the COC had held its meeting and taking its decision, the respondent number 3 filed an application praying for a declaration at NCLT that he was not disqualified from submitting a resolution plan under Section 29A. Now, in December of 2017, the application was allowed by the adjudicating authority by its order of 18th of December 2017, when the respondent number 3 was held to be eligible to submit a resolution plan, notwithstanding the fact that he did extend his personal guarantees on behalf of the respondent number 1, which were duly invoked by some of the creditors, as aforesaid. And it ruled that in as much as the personal guarantee having not been invoked and the respondent number 3 merely having extended his personal guarantee, as such, there is no disqualification per se under 29AH of the code, as the liability under a guarantee arises only upon its invocation. So only those guarantors who had antecedents which might adversely impact the credibility of the process were the only ones who should be excluded, is what was the thought of the adjudicating authority. So as the debt payable by the respondent number 3 was not crystallized, he could not be construed as a defaulter for breach of guarantee and would fall within the exclusions under Section 29, subsection AH. So this order was assailed by the PNB. They challenged it before the NCLAT. And the NCLAT in the appeal has held that in the meantime, if the second respondent filed a resolution plan, the resolution professional and the Committee of Creditors may go through the same, but the adjudicating authority will not accept or reject the resolution plan or pass any order in the lower court without approval of this appellate tribunal. So this was the finding which was given by the appellate tribunal NCLAT in December 2017. Now this resolution plan was submitted by the respondent number 3, was put to vote by the IRP in the 12th meeting of the COC by way of e-voting. So this plan was received by 68.50% vote share of the COC, and there were 6 financial creditors who had voted against the plan. So then extended 270-day period of CIRP had expired on 25th of December already, were to expire on 25th of December 2017. So the RBL Bank filed an appeal against the NCLT order. That was order of 18th December not to accept the resolution plan without its prior approval. Now comes January. Now, January respondent number 3 filed an application invoking section 60 IBC code, seeking an appropriate direction to the dissenting and abstaining creditors to facilitate a possible change of mind by supporting the resolution. So all those creditors who had not supported the resolution plan of the respondent number 3, he had filed an application in order to seek appropriate direction to direct the dissenting or the abstaining creditors to also facilitate a possible change of mind. So Bank of Maharashtra then sent a letter to IRP setting forth its condition for its approval of the resolution plan, but more or less came in line. Indian Overseas Bank was also pleased to give its approval to the resolution plan. So now the resolution plan had gathered an approval or a vote share of almost about 78.50%. This was by 31st of January. Now, in the meanwhile, Section 29AH also went through a further amendment which came into effect from 18 January. So the resolution professional filed a report for recording in increased voting share of 78.5% with resolution plan, which was stated to have been passed. So appeal by RBI and Punjab National Bank in CLAT, which was pending at that point of time, was dismissed as withdrawn on the eligibility of respondent number 3 in view of the resolution plan having reached the mandatory requirement of 75% as is warranted under section 34 of the code. So after the financial creditors had already approved 78.50%, the adjudicating authority also, in fact, disposed of the appeals of RBL and Punjab National Bank. Then, after all of that had happened, the adjudicating authority in April of 2018 approved the resolution plan, which was submitted, holding that there is a marked difference between the extension and exclusion. So this is what we are going to discuss primarily here. So the rigor of section 12(1) of the code would not get attracted on the facts of the case. And it was held that the issue qua the eligibility under section 29AH, which was already decided, coupled with the resolution plan crossing the requisite threshold of approval by the COC, which is 75%. Now, when all of this has been met, the resolution plan submitted by the respondent number 3 was liable to be allowed. So in the meantime, section 29AH went through a further change by way of ordinance. So the government has been making certain amendments in this regard under section 29AH. And that is when the appeals, including that of the appellant, were dismissed on the ground that the resolution plan was approved with 78.50% of the voting share of the COC. And the decision of the adjudicating authority dated 18th December 2017 has attained finality qua the issue of eligibility of the respondent number 3 under section 29A of the code. So this is the brief facts that goes into the decision which subsequently was passed by the Honorable Supreme Court. Now, let me also share a very small PPT that has been prepared in this regard, which probably will give further clarification or clarity in terms of the contentions which were taken by both the parties and the decision that the Supreme Court has made in this regard. Yep. So in this judgment, yeah. Now I think it is clear. So in this judgment, the Supreme Court had interpreted Section 29A of the Insolvency and Bankruptcy Code 2016. In the Bank of Baroda versus MBL infrastructure, the court addressed the question of whether a guarantor whose guarantee is invoked by a creditor is ineligible to submit a resolution plan under Section 29AH of the code. And it also examined whether all the creditors or only those creditors who had instituted the insolvency proceedings were constituted such creditors under the definition of Section 29AH. So the court held that the phrase such creditor under Section 29AH must be construed to mean a similarly situated creditors once the insolvency application has been accepted by the adjudicating authority, and that also has been done subsequent to the majority of the creditors, that is about 78.50% of the creditors having accepted the resolution plan. So the facts is that we have already discussed in terms of the list of dates and events. So I'm not going to repeat all of that. Some of these facts we've already discussed in the list of dates. Now, this is where we had ended the list of dates. So while the appeal was pending before NCLAT in June 2018, Section 29AH of the code was further amended. Now, that amendment that came in under Section 29AH was that a person who has executed an enforceable guarantee in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution has been made by such creditor has been admitted under the code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. That is the amendment which was brought in under the IBC subsequent to the ordinance. Now, this means it is a person who is not eligible to submit a resolution plan. So they are also falling within the categories which have been provided under Section 29A of the persons who are not eligible to participate, and now includes the persons who have executed a guarantee in favor of a creditor in respect of a corporate debtor, which means the promoter of the company who had also given the guarantee. So that was the argument which was taken by the bank. So in August 2019, NCLAT had upheld the NCLT order, who had approved the guarantor's resolution plan. And thereafter, on account of the guarantor's resolution plan having come into effect, the shareholders of MBL approved a fund raising of rupees 300 crores in the MBL's annual general meeting. So this was the decision of NCLAT, which was challenged by Bank of Baroda before the Honorable Supreme Court of India. So the issues which were raised before the Supreme Court was with respect to the interpretation of Section 29AH of IBC. And second was whether the personal guarantor is barred only in cases where the guarantee executed in favor of the creditor has been invoked, as in the guarantee executed in favor of the creditor has been invoked before the commencement of CIRP. So in this context, the appellant submissions that was made is that the respondent number 3, who is a promoter, so appellant is the Bank of Baroda. So their argument that was taken at that point of time was that Bank of Baroda, the respondent number 3, who is the promoter of corporate debtor, was ineligible to submit a resolution plan under 29AH of the code, as there were several personal guarantees which were executed by respondent number 3 in favor of various creditors of respondent number 1, and it had stood invoked prior to the commencement of CIRP. And now this clear suppression of facts on the part of the guarantor was not taken note of by the adjudicating authority on both the occasions when the orders were passed. And even the resolution professional had failed to highlight this fact before the adjudicating authority. So the law which was prevailing on the date of the application has to be seen. Since the disqualification gets attracted on the date of filing of an application, and that was the analogy which was to be drawn, and that only Section 29AH, but also under 34 has to be interpreted. Now, what does Section 30, subsection 4 say? allow me to read it because I don't have it immediately on the screen to be shared. So I can just read it that the committee of creditors may approve a resolution plan by a vote of not less than 66% of voting share. Now that also has changed from 75% earlier to 66% subsequently. So 66% of voting share of the financial creditors after considering its feasibility and viability and such other requirements as may be specified by the board. So those are the two parameters in which it has to be seen. Now, the revised plan before the appellate tribunal was never approved by the adjudicating authority, including the conditional assent, because the assent which was given by the respondent number 11, the banks, which were conditional assent, that was also not taken into consideration. So there is no bar in law for questioning the eligibility before the adjudicating authority, since the appellant was neither a party before it on the earlier occasion, nor an adjudication was made on the merits of the appellate tribunal. That is the argument which the Bank of Baroda had taken. Now, what was the respondent's submission in this regard? The respondent submitted that a decision made by the COC in its commercial wisdom need not be interfered with by this court, and the object of the court has to be read with respect to section 29AH. I think this is one view which has been taken by the Honorable Supreme Court as well as by NCLAT and NCLT on various occasions, that once COC has decided something in its commercial wisdom, the court should not interfere into it. But the legality of it still needs to be tested on whether it could have been done or not. So that is probably why the Supreme Court ultimately had to intervene here. Since the appellant was well aware of the decision of the adjudicating authority, the appellant was stopped from questioning the eligibility of respondent number 3 to submit a resolution plan, which was passed under section 29AH of the court. So if we look at the literal interpretation of the provision, the personal guarantor is barred. I mean, the section 29AH talks about it. But only when the creditor invoking the jurisdiction of the adjudicating authority has invoked the personal guarantee executed in favor of the said creditor before the initiation of CIRP. Here, no personal guarantee was invoked by RBL Bank at the time of filing of section 7, and the invocation of the consortium guarantee by some banks were ex facie illegal in terms of the agreement which were executed between the members of the consortium of banks. And so what was the argument of the respondent was that both the NCLT as well as the NCLAT have rightly construed the issue with respect to extension and exclusion. And there was no infirmity that requires the intervention of the Supreme Court. So in this, the judgment which was passed was with respect to, in order to prevent any interpretation that would result in harm or undermine the purpose of the law, the court intended to interpret the principle in accordance with the nature of the act and its provisions. So the Honorable Supreme Court referred to different statute of interpretation rules and cases that were relevant to it, including the Maxwell interpretation of statutes and the craze in statute law, and Union of India versus Elphinstone judgment also. And before coming to the conclusion that the court had already been interpreted numerous times in the past using the same rules and the same principles with the goal of preserving both the letter and the spirit of the law. So the purpose of the code, according to Supreme Court, was to revive and rehabilitate the corporate debtor, and it could not have been done without the active involvement of the creditors, which has already been considered by Supreme Court earlier. And in order to support the reasoning, the Supreme Court relied upon the Swiss Ribbons versus Union of India ruling, in which the aim and purpose of the court were thoroughly discussed. And it was determined that the primary goal of the legislation is to ensure the revival and continuance of the corporate debtor by safeguarding it from corporate death by liquidation. Now, this is where the interesting scenario emerges, because in the past, in the various judgments, the way the courts have interpreted 29A is very interesting. And therefore, while 29AH may not have been discussed in as much detail in the other judgments, there have been some discussion with respect to 29A, definitely in the other judgments as well. So let's look at what are the other judgments and what has been the finding of the courts in that regard. So in this case, the Supreme Court then also observed that the objective behind 29A is to avoid protecting the resolution plan from unwarranted persons who wants to indulge in the resolution plan for their own personal interest. And secondly, the provision prevents those persons who lack confidence in the resolution process by virtue of their disqualification. So it is the intent of this provision to bar those persons who are in the management of the corporate debtor, who is going through the IBC and on account of whom this insolvency has arisen. So there is a whole concept that it is because of those promoters' actions or inactions that the corporate debtor has reached this stage. And that was the preset mindset with which the Supreme Court in the earlier judgments had interpreted those issues. But Section 29AH, in the peculiar circumstance of this fact, has a little different connotation, and I think it has been very interestingly observed also by the Honorable Supreme Court in this case. So the Supreme Courts in the past have said that if these persons who are disqualified under 29A, they are allowed to participate in the resolution process, they will certainly regain control of the corporate debtor, and the whole process will ultimately undermine the intent of the legislation. So the Supreme Court took note of its own decisions in the case of Chitra Sharma versus Union of India, and also in the case of Arun Kumar Jagatramka versus Jindal Steel and Power Limited. So these two judgments, they have discussed on the issue of 29A, in which the Supreme Court discussed the significance of a purposeful interpretation of the court and the provisions in light of the court's objective, which is to revive the corporate debtor. So in these judgments, the Supreme Court interpreted the purpose of and also the necessity of why 29A has been introduced in the first place. And it observed that by doing so, the Parliament had remedied the mistake that enabled the backdoor entry of the erstwhile managements in the process of CIRP. So in the last few years, there have been almost, if not less, about 8 to 9 judgments which have been passed by the Honorable Supreme Court and which has been discussed here. Some of them are, I mentioned, Swiss Ribbons versus Union of India, Arun Kumar Jagatramka versus Jindal Steel and Power Limited, which has been discussed here, Chitra Sharma and others versus Union of India, which has been discussed, the ArcelorMittal India Private Limited versus Satish Kumar Gupta has also been discussed in this judgment. Then Phoenix ARC Private Limited versus Paid Financial has been discussed. Then the Committee of Creditors of SR Steel versus Satish Kumar Gupta. Then DBS Bank versus Sharad Sanghi has been discussed. EBIC's judgment has been discussed in this, and then also the National Spot Exchange judgment has been discussed here. So this judgment is, is a consolidation of all those very interesting judgments and findings that have been given by the Honorable Supreme Court, and has, in that context, discussed some very interesting issues. So the Supreme Court in this case observed that the Section 29AH creates one more class and of persons who are ineligible to be a resolution applicant. And as per the provision of if the application for insolvency has been admitted and the guarantee has been executed by the guarantor and it has been invoked, then ineligibility under the said provision will come into play. So the only requirement is the guarantee in favor of the creditor. Once an insolvency application is admitted, then all creditors would have their rights at par with each other. And therefore, the word such creditor has to be interpreted to mean similarly placed creditors. So the Supreme Court, in fact, held that that ineligibility must be seen from the perspective of the corporate debtor's resolution procedure to provide for a fair and transparent process. So the Supreme Court, in fact, held that such guarantee has been invoked by the creditor and remains unpaid in full or part. So that is when there is a default. It has been executed in favor of a creditor in respect of a corporate debtor against which an application for insolvency resolution made by such creditor has been admitted, and such guarantee has been invoked by the creditor and remains unpaid. Now, this is where the whole focus has been in the statute also and the judgment also. So this constitutes this latter part of the provision should be accorded equal weight. So the Supreme Court had considered the position of the resolution application if the plan is maintainable, when it is maintainable, but subsequently it becomes ineligible owing to a legislation amendment. So the Supreme Court, in fact, ruled that the amended provision would govern the resolution applicant's eligibility, since it is the duty of the resolution applicant to facilitate the resolution process. In fact, in this case, the Supreme Court also observed that the time at which the guarantee was invoked by some creditors, the rigor of 29AH comes into play. And as per the wide import of Section 7, it cannot be restricted to those creditors, but will cover the entire class of creditors. So the Supreme Court said that the NCLAT and NCLT had erroneously dismissed the applicant's allegations because the previous complaint was withdrawn without the deprivation of liberty, and the eligibility issue can never be, could not have been raised. At that point of time, it could not have been raised. So the court upheld the adjudicating authority and the appellate tribunal's decision on the question of limitation. It agreed that invocation of Section 12(3) of the code with respect to the delay was rightly condoned. It further stated that the resolution plan which was submitted by Resolution 3 was ineligible for submission. However, it cannot be revoked as it has the mandatory voting share requirement as is required under Section 30, subsection 4 of the code. And since the resolution plan was already accepted by more than the required voting percentage of the COC, and much development has been made, the court observed that IBC's ultimate goal was getting a corporate debtor back on its feet. And it also said that the dissenting creditors would not suffer any harm since their interest would be protected by the resolution plan, which allows them to recover the liquidation value of their respective credit limits. And therefore, as a result, based on the unique facts of this case, the court did not interfere with the guarantor's resolution plan. So I think the court has found via media, the court did not appreciate the manner in which it was done. But then because it was already done, it was already implemented, it was already accepted by the large number of the Committee of Creditors members, almost like 78.50%. Therefore, the court did not set it aside or revoked the resolution plan which was submitted by the guarantor. So that is the interesting part of this judgment, in fact, where the Supreme Court has given this kind of an understanding in this regard. Now, the other judgments that I mentioned with respect to this issue, which also are very interesting ones. The first one that I mentioned was the Chitra Sharma case. The Chitra Sharma case, in fact, had a very interesting, discussion in this regard, where let me see if I have a slide on that. I'll try to show it to you because Chitra Sharma, the court had given a very interesting interpretation on 29A of the IBC. Because there the Supreme Court had said that the provisions of 29A are intended to ensure that among the other persons, the persons who are responsible for insolvency of the corporate debtor should not participate in the resolution process. That was the whole thought process with which the Supreme Court had decided the issue of Chitra Sharma. Yeah, I think I have found this thing. Yeah. So this is what the finding of Supreme Court here was, that the statement of objects and reasons appended to the IBC Amendment Bill of 2017 which was ultimately enacted as Act of 8 of 2018, states thus: the provisions for insolvency resolution and liquidation of a corporate person in the code did not restrict or bar any person from submitting a resolution plan or participating in the acquisition process of the assets of a company at the time of liquidation. But concerns have been raised with respect to the persons who, because of their misconduct, has contributed to the defaults of the companies or are otherwise undesirable and may misuse the situation due to lack of prohibition or restriction to participate in the resolution or liquidation process and try to gain control of the corporate debtor, even though they made the corporate debtor reach this situation because of their own inactions. And therefore, what the Supreme Court had held in that case is that this may undermine the processes laid down in the code as the unscrupulous person who would be seen to be rewarded at the expense of the creditors. In addition to this, in order to check that the undesirable persons who may have submitted the resolution plans in the absence of such a provision, the responsibility is also to be entrusted on the committee of creditors to give a reasonable period of time to repay overdue amounts and become eligible. So the parliament at that point of time had evidently concerned over the fact that the persons whose misconduct has contributed to the default on the part of the debtor companies may try to misuse in the absence of a bar on their participation in the resolution process to gain an entry. And the parliament was therefore of the view to disallow such persons to participate in the resolution process, and it would be necessary to meet the objects and purpose of the code itself. Now, so far as the other judgments are concerned, the next judgment that has been discussed here, which gives further clarity, is the judgment of Phoenix ARC versus Paid Financial Services Private Limited. Now, in this judgment, the Supreme Court has, in this case, the Supreme Court considered the principle of purposive and creative interpretation while approving the interpretation which was given and the approach which was taken by the court in the earlier decision of ArcelorMittal's case. And the Supreme Court, in fact, held in this case was that this court has approved of a purposive interpretation of Section 29A of IBC in the ArcelorMittal India Limited versus Satish Kumar Gupta case, where it was observed that after discussing various judgments, that after referring to the golden rule of literal construction and its older counterpart, the object rule in Hayden case referred to the theory of creative interpretation, and which is that the instances of creative interpretation are when the court looks at both the language as well as the purpose or object of the statute in order to better determine what the words used by the draftsman of the legislation means. Now, if we take this judgment of Phoenix ARC and put it into the present judgment of Bank of Baroda versus MBL, in that case also, while there can be a literal or a strict interpretation of the provisions of Section 29AH, which ought not to have permitted the respondent number 3 from participating in the process or to have submitted the resolution plan, or the committee of creditors taking a decision with respect to the resolution plan submitted by the respondent number 3. But then keeping in mind the purpose or the object of the code, which is to revive the company, which is to rehabilitate the company rather than leaving it to meet its corporate death, that the Supreme Court had intervened in this case as well and had permitted the resolution plan, which was submitted by the respondent number 3, that is the promoter and the guarantor of the company, and which was already voted to by the larger number of committee of creditors, and it already had the majority of with almost 78.50% of the committee of creditor members having given its assent in that regard. So the whole argument is with respect to the discussion of the term, the manner in which the statute has to be interpreted. So at the Supreme Court level, when the interpretation has to be done, the interpretation has to be liberal in order to take into consideration the object and purpose of the code. So in this Phoenix judgment, the Supreme Court had also talked about the term Lakshman Rekha, which was in fact extended to move away from the strictly literal rule of interpretation back to the rule of the Old English law of hidden case, where the court must have a recourse to the purpose, the object, text, and context of a particular provision before arriving at a judicial result. And in fact, the wheel has turned full circle in that regard. And the whole intention behind Supreme Court relying on these judgments also was that this Lakshman Rekha is not the final word. And it is not that the Supreme Court cannot go beyond this Lakshman Rekha. It has to be still seen what is the purpose, what is the object, text, and context of any statute in that regard. So it was in this so I think this we have already discussed. These judgments we have already, this is a part of our same judgment. So the interesting thing is these two judgments, and then also the judgment of Swiss ribbons. In the Swiss ribbon case, also the Supreme Court had discussed on the issue of 29A, although in a different context, but the Supreme Court had upheld the constitutional validity of 29A. And that was, in fact, of course, challenged there. And there the issue was that the application was moved by Swiss ribbons under section 29A, which is a disqualifier section. And it was alleged to be unconstitutional since it was an apparent breach of the right to equality, which was enshrined under Article 14 of the Constitution. So this test which was laid before the Honorable Supreme Court in that case was whether the section 29A disqualifier with respect to certain identified persons was in breach of the right to equality, which has been enshrined under the Constitution of India. So the questions were raised on the grounds that the presumed vested interest and malfeasance by all the promoters without differentiating between the two sets of promoters. One could be unscrupulous promoters, but then there are some who may be good and may just be, falling within this bracket because of a lot of factors. It is not that all the promoters who are unscrupulous and because of whom the company has reached this stage. There could be various other reasons for the company to have, gone bust. So the blanket ban which was imposed under Section 29A was the whole set of challenge. And it was considered to be unconstitutional as per the petitioner in that regard. It was in fact also argued there that by negating the promoters as an entire class, the genuine promoters who are also in fact capable of outdoing the bids of the other resolution applicants, they were also aggrieved because they were not getting the opportunity at that point of time, and even now, to be able to participate in the bidding. So on the consideration of the arguments, the Supreme Court had observed in this case that Section 29A of the code, it includes in its purview all those persons or the class of persons who have been considered to be unfit for acquiring, for managing, as well as for reviving the business of the corporate debtor in question. So the category of persons, if you look at under 29A, are the insolvent persons, are the persons who were managing the accounts which have been classified as NPA, and various other categories, including the guarantors, which we just discussed under 29AH. So far as the maximization of value by genuine promoters is considered, the Supreme Court had said that the code provides a window by way of Section 12A for withdrawal of the corporate debtor from CIRP. And in fact, thereafter, there are multiple cases where, in fact, there have been withdrawal, which has happened after the settlement has been arrived at between the debtor and the creditor in that regard. Then in the next case, which we had mentioned and was discussed, was Arun Kumar Jagatramka versus Jindal Steel and Power. In this also, there was a discussion with respect to 29A. So here the Supreme Court had said that it went into the whole basis of the enactment of IBC, and it said that it marked a quantum change in the corporate governance and the rule of law. So the understanding of the Supreme Court was that firstly, the IBC perceives the good corporate governance. It has a respect for and adherence to the rule of law as a central to the resolution of the corporate insolvencies. And secondly, in fact, it also had held that the IBC has perceived the corporate insolvency not as a particularly isolated problem. It is not faced by individual business entities, but it places it in the context of a framework which is founded on a public interest as the core, which facilitates economic growth. And how does it do it? Is by balancing the business decisions which are taken by the creditors, acting as a collective body on the premise that the timely resolution of corporate insolvency is necessary to ensure the growth of credit market and encourage investment. And there are a lot of various other factors which have also been taken into consideration. So in that context, when 29A was to be discussed, it has been, the court upheld 29A by saying that it was enacted in the larger public interest, and it is to facilitate the corporate governance norms. And then therefore it observed that there was a loophole which the parliament had identified and had rectified. So there was no need for interference with respect to the promulgation of 29A. And the ineligibility under 29A was to achieve a sustainable revival and to ensure that a person who is, who's the cause of the problem, either by way of design, purposely done, or because of default, which is not within his solution, he does not need to be a part of the process. And therefore, 29A must be noted encompasses not only conduct in relation to the corporate debtor, but in relation to other companies as well. So this was the basic foundation of the judgment which was passed in Arun Kumar Jagatramka's case. So having discussed all of these judgments and all of these in the purview of 29A, where there was a reason for the court to have not interfered with the legislation per se, the interesting part is the present judgment of Bank of Baroda versus MBL, where the Supreme Court has now gone on to interpret 29AH, which was not done in any of these judgments. They primarily focused on 29A and the exclusions under 29A in general, and why it should be done, and how the exclusions were justified. But in this case, in 29AH, where it was talking about the guarantors, the Supreme Court has given a liberal interpretation, as I would say, not followed the Lakshman Rekha in terms of barring it completely, and has tried to find a workable solution around the concern that was existing at this point of time, and has probably balanced it out, understanding the statement of object of the code itself, and which is to revive the company or rehabilitate the company rather than killing the company itself. So I think it is a business oriented kind of a decision. It has been thought through well by the Supreme Court. And, it is only Supreme Court who could probably have done this, because for the NCLT and for the NCLAT to have interpreted in this manner probably would not have been seen in this light. But because Supreme Court has the powers to be able to do that, and it has been done in a very methodical manner, taking into consideration all the judgments and the entire discussion around 29A, and still found this judgment finds a viable solution because of the actions which have already subsequently been taken. Because after the decision of COC and thereafter it having been implemented, I think that was a workable solution which the Supreme Court has found. So that is what my two bits are on this judgment. If there are any questions, I would be happy to take. Otherwise, I think the next speaker is also now scheduled to speak from 5 o'clock. So we can start the session on the next one. Thank you so much for the patient listening.
If there are any questions that may be asked. Thank you so much, ma'am, for taking us through the judgment of Bank of Baroda versus MBL and various other judgments related to Section 29A. It was very detailed and informative. Thank you so much.
Thank you. Thank you so much. Thank you for the opportunity. Look forward to connecting with you again.
Yes, ma'am. So now the next session will be taken by Mr. K.C. Aggarwal. I shall briefly provide you the introduction of Mr. K.C. Aggarwal. Mr. K.C. Aggarwal is an insolvency professional and a practicing advocate. He has unique and more than 40 years long experience combining of adjudication, implementation, and practice of law. He started as a judge in Rajasthan Judicial Service in 1978 and switched over to civil service in 1982. Having served in various departments in government of Delhi and Andaman and Nicobar Islands administration, including on the post of law secretary, retired in 2014 from Delhi government as special secretary. Thereafter, he is practicing as a lawyer in High Court as well as Supreme Court, apart from being an insolvency professional. So you may now start the session.
Thank you for the introduction, and I hope I am audible to all.
Yes, sir, you're audible.
Thank you. You see, the case which we are going to discuss is not directly on IBC, but has a very important bearing on IBC. And if you see that none of the IBC provision has been interpreted in it, but by implication, you will find that there are important implications from this. The judgment which we are going to discuss is Prakash Corporates versus DV Projects Limited. It has been reported at, I will share the screen. Please allow me a few seconds. I hope it is visible now.
Yes, it is.
Okay, thank you. So this is the citation of the case, and if it can be found in many of the reports. It has not been analyzed in many of the journals and reports which report actually the IBC cases. It is, of course, available in other law journals which are actually reporting general cases. And it has not yet been referred to in any other case by the Supreme Court. It has been referred to by some high courts in some cases, just by way of, you can say, following it, but it has not been analyzed again in any other case or distinguished or explained or elaborated or narrowed down. And therefore, this is actually the last word, whatever has been said here. There are many provisions which have been referred in this case, and all these provisions have been referred with reference to the extension of limitation which has been granted by the Supreme Court in a suo motu writ petition, that is suo motu writ petition number 3 of 2020. These provisions which have been referred and have been actually discussed with reference to the application of extension of limitation by the Honorable Supreme Court. They are Section 138 of Negotiable Instruments Act. You will find in my presentation, I have written demand, payment, cognizance, and then Section 142 in the bracket. That means demand and payment, they are actually provided in subsection B and subsection C respectively of the Section 138 of the NI Act. In Negotiable Instruments Act, Section 142 provides for filing of a case, limitation for filing of a case before the court. Whereas subsection B and subsection C of Section 138 provide respectively for limitation for making a demand, and time within which a payment can be made to avoid criminal liability. The difference is that in none of the orders of the Honorable Supreme Court, Section 142 has been referred. Therefore, whatever has been discussed in the Honorable Supreme Court's case is about subsection B and C of Section 138, that is with regard to the limitation for making a demand or limitation for making a payment in response to the demand. Similarly, it has been discussed as to how much limitation will get extended with reference to Section 29A, which provides for limitation of making an award by the arbitrator or the arbitral tribunal, and Section 23(4), subsection 4 of Section 23 of the Arbitration and Conciliation Act, which provides for limitation for completing the statement of claim. Then they say it has been made under Article 142 of the Constitution of India. There is a reference to Article 21 also. Then there is a reference to Section 4 of the Limitation Act. This particular provision provides that if on the last day of limitation the court is closed, then the limitation gets extended till next working day of the court. Then it has also come into discussion whether limitation is extended in case of criminal matters also, for filing of investigation report. They say final report of the investigating officer, because you see there is a limitation provided if within a particular period the charge sheet is not filed, then the accused becomes entitled to bail. It no more remains a discretionary power with the court to grant or not to grant bail to the accused if the charge sheet is not filed within time. So this has been discussed, and actually it has been discussed if limitation doesn't apply to criminal matters, then how can they be applied to the civil matters? And in this particular case, the bone of contention is whether limitation for filing written statement was rightly refused by the trial court and the high court, or it should have been extended. That is the crux of the matter in this particular case. And this filing of written statement has a bearing on IBC because one party who is to file the written statement has already filed a case under Section 9 of IBC for insolvency resolution process as an operational creditor. So that is where it has a bearing, although the entire discussion is whether the limitation for filing the written statement has expired or whether the right to file the written statement got forfeited or whether the time still got extended. So directly it does not discuss IBC, but yes, it has a bearing on IBC as to how far civil suits and their proceedings have a bearing on initiation and continuation and their implications of CIRP. You see, as a matter of fact, technical rules of CPC, they say, are not applicable. But by actual experience, you will find that provisions of CPC are so essential. The knowledge about these provisions is so essential that without these knowledge, hardly any proceedings before the NCLT can be properly handled, either by insolvency professional who is appearing before it, or by advocates or by parties. The other provisions referred are the Commercial Codes, Section 12A, which provides for limitation for pre-institution mediation of, they say the limitation is 3 months and maximum 2 months can be extended, and the period spent in the pre-institution mediation is excluded from the limitation. Then Order 7, Rule 11, that is about making up the deficiency of court fee. Then main provision is Order 8, Rule 1, Rule 10, and Order 5, Rule 1, Sub-Rule 1 of CPC. All these rules actually prescribe the time limit for filing of written statement. They say these provisions provide 30 days within which the WS has to be filed, and power of the court to extend it by another 90 days. Section 12A of the Commercial Codes Act, apart from providing this limitation for pre-mediation, pre-institution mediation, the Commercial Codes Act also has amended these rules of CPC in their application to commercial disputes, saying that the maximum period within which the for which the time can be extended by the court is 120 days, not 90 days. And it adds further that after 120 days, the party shall forfeit its right to file the written statement. That is only applicable to commercial disputes. The liability to forfeit the right to file written statement is provided only for commercial courts. So that is these are the provisions which have been discussed. Section 9 of the IBC has been only mentioned that yes, a petition was filed. I hope my voice is audible to all, and I am making it, I mean to say, across the to everybody.
Yes, sir, it is audible to all of us.
Thank you. Thank you. The judgment is actually in various parts. It is nowadays the Supreme Court in many cases, or in most of the cases, is giving also a kind of index or a kind of index in the judgment. So I have tried to summarize my discussion in accordance with that index which the Supreme Court has given in its own judgment. The first point they have raised is the preliminary matters. What is the preliminary background? That gives you the list of dates actually. On 22nd of June, order was passed by Commercial Court. On 9th of July, the order was passed by the High Court of Chhattisgarh, which upheld the order of the Commercial Court not to allow to file written statement. And on 14th of February, this particular decision was rendered by Honorable Supreme Court, which we are discussing. And the entire matter is with regard to extension of limitation. Here I would like to make a particular reference to the distinction between condonation of delay and extension of limitation. Whereas extension of limitation is a right. In case you satisfy those conditions, that becomes a right. And condonation of delay there is an amount of discretion involved by the court, and only when the court considers it appropriate, then only the delay is condoned. It cannot be condoned as a matter of right. Merely because the court has power to condone delay, the parties cannot claim the condonation as a matter of right. In this particular case, you will find that this distinction is very important. For example, filing an appeal before the appellate tribunal under the IBC, there is a time limit prescribed, and then there is a condonation of delay that is given. Now, the Supreme Court orders have extended the limitation, but they have not extended they have no impact on the discretion about condonation of delay. So if the limitation has expired even before extension of the limitation by the Supreme Court, then the party may not have any remedy, and the party may not be able to file its appeal. So that is the distinction. Let's go to the second part. What were the facts? The facts in this case were that these two parties, I have mentioned in my presentation, this DFA and PTR. In red you are seeing. DFA means defendant appellant. That means Prakash Corporates. And PTR means plaintiff respondent. Because this entire case is with reference to a suit, therefore, the parties referred as plaintiff and defendant. The plaintiff before the commercial court became respondent before the Supreme Court, and the party who was defendant in the commercial court became appellant in the Supreme Court. Therefore, DFA means the appellant, that is Prakash Corporates, and PTR means the respondent, that is DV Projects Limited. Now what happens? What are the facts? Over 17.94 crores, say around 18 crores, demand notice was given for some operational debt by Prakash Corporates on 1st of July 2020. On 13th of July 2020, a reply came wherein they said it is not only wrong to demand any money, but as a matter of fact, there is an overpayment of over rupees 3.73 crores. On 11th of September, that is 2 months thereafter almost, an application under section 9 of the IBC was filed by the appellants. This spelling needs to be corrected. After that, almost 3 months thereafter, the respondent filed a civil suit for recovery of the amount of rupees 3.73 crores. And they also filed an application under Order 38 Rule 5. I said that CPC would be required everywhere you proceed, even in NCLT. And as a matter of fact, CPC is so essential to be known that in any legal matters, you will always find it very handy to have the knowledge of CPC. In fact, I would rather say that all the insolvency professionals who are not lawyers, who have not studied law, they must study CPC so that they become aware. As I am referring to Order 38 Rule 5. Now, it is actually in this particular case, I am explaining that this particular rule provides for attachment before judgment. It provides that the party who is filing a suit can also apply to the court that the other party may run away, may disappear, or may even fritter away the assets. And therefore, even before the judgment, let the money which is involved in the suit be safeguarded, be attached. Even if it is not paid to the plaintiff, let it be attached. So that is done under Order 38, Rule 5. So many applications actually, in one of such webinars, some insolvency professionals pointed out that sometimes the court would say, okay, no tera ki application laga dijiye. Now every person who is not aware of CPC will not understand what is no tera. That is actually restoration of the ex parte order. So similarly, 38(5) means attachment before judgment. This is generally, actually, there are so many provisions in CPC where such applications are provided. For example, amendment of pleadings, framing of new issues, or addition or deletion of parties. So all these things, when they are taken up there, maybe CPC is not applicable in its technical, you can say, shape, but the spirit of the CPC is very much applicable, and actually that is very essential. I am repeating it at the cost of repetition. I must say that this is very essential for every person having to deal with NCLT. Okay, let's proceed further. Then the appellant, I mean to say Prakash Corporates, filed an application under section 10 of CPC, that is for stay of suit, on 18th of January 2021. On 2nd of February, both parties sought time. On 24th of February, time for filing written statement was given at a cost of rupees 200. Again, at a cost of rupees 500 on 15th of March. And on 15th of April, while this was going on, administrative orders of the Chhattisgarh High Court came, which provided for truncated operation of the courts in the entire state. It provided for timing. It provided for that in case there are more than 3 courts, then only 50% courts will function. The courts will function only between 11 a.m. to 2 p.m. like that, and they will only deal with particular matters which are of urgent nature. This has a very great bearing on the question of limitation, which has been discussed by the Supreme Court, and Supreme Court has actually considered this as very important while considering whether it was possible for a person to actually have the matters filed or processed in the court, whether the courts can be considered to have functioned normally in that period in view of this particular order of the jurisdictional high court. Now, as you know, in commercial cases, the limitation for filing the written statement is maximum 120 days, and therefore the suit, the 120 days from 6th of January 2021, they came to an end on 6th of May 2021. And what the order of the commercial court said, there were 2 things. There were 2 applications pending. Order 38, Rule 5, that is attachment before judgment. There was an application under Section 10 CPC, and there was also a matter regarding filing of written statement. The trial court, the commercial court said, your right to file written statement stands forfeited, and the court has no power to extend it. And as regards other two applications, the matter was adjourned. When this right was forfeited and the appellant was not, Prakash Corporate was not allowed to file written statement in the suit filed by Messrs. DV Projects, it approached High Court in a writ petition. Main grounds taken were that on 6th of May 2021, court was closed. There were medical grounds about the partners of the firm. And then it said that the orders passed by the Honorable Supreme Court in suo motu writ petition number 3 of 2020, the benefit has not been given of that order. And once the Supreme Court has extended the limitation, neither the commercial court nor the High Court was right in refusing the time to file a written statement. It was opposed, this writ was opposed, saying that these were appealable orders and therefore writ doesn't lie. Although there is no hard and fast rule that writ does not lie where the order can be appealed. But generally the High Courts do not prefer, and even Supreme Court says that writ may not be entertained when there is an alternative remedy. Appeal is an alternative remedy, and when that alternative remedy is available, then writ is not maintainable. Generally, this is what they say. And second ground to oppose this writ petition was that after 120 days, the courts do not have any power to extend the limitation. And the two cases cited were SCG contracts and Sagufa Ahmed case in support of the opposition to the writ by the plaintiff, opposition to the writ by the defendant. The writ was filed by the Prakash Corporates and it was opposed by DV Projects. So these were the grounds taken by DV Projects, and actually Prakash Corporates lost before commercial court and also lost this writ before the High Court of Chhattisgarh. The Chhattisgarh High Court said that writ is maintainable even if there is an appealable order, or whether it was also not considered appropriate to say that the order was appealable. But then relief was not granted. Why? Because they said that there is no power to extend limitation under this particular enactment, Commercial Courts Act, in view of a specific provision that no court shall have power to extend it beyond 120 days. And then they distinguished between condonation of delay. They said that WS is yet to be filed. Had it been filed, then it would have been a matter of condonation of delay only, but it is yet to be filed. So these were the two main grounds on which the relief was not granted. The parties then came to the Supreme Court. And in the Supreme Court, I will try to summarize it as soon as possible so that some time is left for question and answers. The rival submissions I can summarize very briefly. They actually took the Supreme Court through the various proceedings in the suit. So you see, whenever you deal with the matter, the proceedings of a suit, that is why I say the provisions of CPC are very important. Those proceedings will show how the case has progressed and how the CPC has actually been applied or should have been applied. Then various orders of Supreme Court passed in suo motu writ petition number 3 of 2020. The one order was passed on 23rd of March 2020, and this order was operative when the suit was filed. As you remember, The suit was filed on which date? The suit was filed before the court. I may take you to the concerned slide. December 21st, 2020. That is when the suit was filed. And as per that order, the period between 15th of March 2020 to 2nd of October 2021, as per this order and as amended thereafter, all this period was excluded from limitation. And therefore, they said that there was no delay and no explanation is required. Whenever there is a delay, the court requires that there has to be a day-to-day explanation. And only if convincing day-to-day explanation is given, then only that delay is condoned by the courts. But in this case, they said that because the Honorable Supreme Court has extended the period of limitation, there is no delay and therefore there is no need to explain it day by day. Then they said that Raipur district where the matter actually proceeded, it was in the COVID containment zone. Then there were medical sickness, and due to that medical sickness, even mother of the partner passed away, and limitation was totally under eclipse. And then there was administrative order of the High Court, and they did not take up the stay application. On one hand, although the written statement was ready and it was all notarized, I have not gone to the details as to what were why the dates were sought on for filing written statement on different dates. But it is material that on 7th of July, Messrs. Prakash Corporates got its written statement notarized to be filed, which was not allowed by the court. So they had a documentary proof that yes, the written statement was ready to be filed. The plaintiff respondent, that means DV project, said no extension is possible for the filing of the written statement, and they have not used the opportunities. They appeared. That was their statement. That was their argument, that the defendant appeared many times but did not file the written statement. And the court has no power. There is no universal extension. And they also cited a case under CRPC where the Supreme Court has refused benefit of its own orders passed under suo motu writ petition number 3 of 2020. These two cases were distinguished by Prakash Corporates. The cases which were cited by DV projects in order to deny further opportunity or in order to allow the appeal by the Honorable Supreme Court, they opposed it and distinguished those cases. This we will discuss briefly. The principal question therefore remains whether written statement could be filed, could be allowed to be filed or not. And other provisions which came in discussion or consideration by the Honorable Supreme Court was period for pre-institution mediation and the amended provisions of CPC by commercial courts. As we have already discussed, from 90 days it was made 120 days, and then there was provided provision for forfeiting the right to file the written statement with no power to the court. The Honorable Supreme Court has also briefly discussed the impact of COVID-19 on the entire matters at issue. It discussed that the powers, the orders given under suo motu writ petition number 3, actually they were issued under Article 142. And Article 142 gives Supreme Court a power to do complete justice. Although there are limitations on this power, but by and large, there are no limitations. Those limitations are in the nature of that they cannot go beyond, they cannot go against fundamental rights. They cannot go against Constitution. Apart from that, Supreme Court has hardly any other limitation as far as their powers under Section 140, under Article 142 are concerned. On 23rd of March 2020, the period of limitation under general or special law, whether condonable or not condonable, they were extended till further orders. At that point of time limit was not given. On 6th of May 2020, Honorable Supreme Court extended limitation till 15 days after the lockdown for cases under 138 NI Act, Negotiable Instruments Act, particularly subsection B and subsection C. On 10th of July, they also mentioned Section 29A and Section 23, subsection 4 of the Arbitration and Conciliation Act, and provided that limitation would be extended till lockdown plus 45 days thereafter. So that was the order passed on 10th of July 2020. On 8th of March 2021, the order passed was that the period till 14th of March 2021 will get excluded. And if there is a balance period after that, some balance period of limitation, if it is 90 days, if it is less than 90 days, then the party will get a 90 days period of limitation. And if it is more than 90 days, then the party will get the longer period. It will not be shortened. So the idea was only to give benefit and not to curtail any benefit. So that is the order passed on that date. On 23rd of March 2021, the order dated 8th of March 2021 was restored till further orders. On 27th of April, it was again restored and was applied to Section 29A, 23(4), 12A, 138B and C of the Negotiable Instruments Act. Then it discussed the effect of the, it even actually quoted the entire order of the High Court of Chhattisgarh about functioning of the courts in that state. It provided for rotational basis on which the court will function, and 50% courts will function if there are more than 3 courts at a place. The courts will function between 11 a.m. to 2 p.m. Only the specific matters were allowed to be taken, and that too up to a limited number. And there were certain other provisions for courts in the containment zones. So after discussing all these things and COVID and the provisions and the orders passed by the Honorable Supreme Court in that suo motu writ petition, it discussed what is the consequence of a default. So, as you know, the provision is 30 days, 120 days, and then forfeiting the right to file written statement. That is the provision. In SCG contracts case, it was held that even by exercising powers, the inherent powers of the court under section 151 CPC, the period of 120 days cannot be extended. And now the question is whether the orders passed by Supreme Court have no application, whether the orders, the provisions of 120 days and then the provision for forfeiting the right to file or liberty to file the written statement, they cannot take any cognizance of the abnormal status. This was discussed by the Honorable Supreme Court. In para 19.6 of the judgment, it says that legal effect and coverage of the orders passed by the Supreme Court cannot be unnecessarily narrowed down. They also mentioned that exclusion of limitation period is provided under the Limitation Act, particularly in provisions section 12 to 15. And period to be, and that period which has been ordered to be excluded from filing limitation, that has to be excluded from filing the WS also. So in effect, it decided, it gave an opinion in favor of Prakash corporates. And they say, what they say, it would be very illogical that you are extending the limitation for filing a suit, but then you say that written statement cannot be filed because the courts have no powers. So they say, the Honorable Supreme Court noted that it would be illogical if the written statement is not allowed to file. And therefore, the right to file, the time period within which the defense written statement could be filed did not come to an end in view of the Supreme Court's analysis or judgment. 4-5 cases have been discussed in this case. They are very important. In SS Group, the written statement filed on 31st of August was allowed. 31st of August 2020 was allowed, although the limitation expired on 27th of August itself. And that was because the Honorable Supreme Court, this is a consumer matter. This is a consumer matter. And in the consumer matter, the application of these extension orders of the Supreme Court was considered. In another case, in New India Assurance Company Limited versus Hill Multipurpose Cold Storage, again a consumer case, they said the limitation is deemed to be extended by virtue of orders of the Honorable Supreme Court. But then there are two contrast cases where Honorable Supreme Court did not give benefit of the orders passed in suo motu writ petition. In this particular case, the charge sheet was not filed by the investigating officer before the criminal court. They said it concerns personal liberty and it is referable to Article 21, and therefore the extension of limitation is not applicable in this case. Sagufa Ahmed case is a case which is directly under IBC, which they have discussed, and it may be interesting to know that they have distinguished between extension of limitation and delay condonation. They said exclusion of period is only in later orders. In the beginning orders by the Supreme Court, the word exclusion was not mentioned. And even limitation expired on 18th of March 2020 whereas lockdown started on 24th of March 2020. So therefore, they said this particular case is prior to the lockdown, and therefore the benefit of orders of the Supreme Court for extending the limitation cannot be given. It was also raised that the defendant has been appearing on each date. Defendant has been filing its application for a stay of suit also. But defendant has not filed the written statement on any of the dates, and therefore they should not be given benefit. But the Honorable Supreme Court did not agree to this argument. And it particularly noted that when both the pending applications were adjourned, there was no logic in not giving time for filing written statement. A very important concept has been analyzed and applied in this particular case by the Honorable Supreme Court, that is dies non judicious. As you know, dies non is the period of absence, period of when a particular person in government service or in any service, he doesn't appear and he is treated as dies non, means he is treated as not being on duty. Similar to that, as regards courts, there is a phrase dies non judicious. It has been analyzed that process cannot ordinarily be issued or be executed or returned, and courts do not usually sit on that day. So under this provision, Section 4 of the Limitation Act, which we discussed earlier, that on the court is closed, whether the question came before the Honorable Supreme Court, whether the period during which the administrative orders of the jurisdictional high court were applicable, whether that period can be considered as dies non judicious. And in order to decide that, they actually discussed this particular concept, and they said it is on Sunday it is dies non judicious. On any holiday it is dies non judicious. But that does not mean that nothing can be done on those days. What cannot be done is that ordinary process, ordinary matters cannot be taken up in those days. Only extraordinary matters can be taken up. Only extraordinary and limited issues can be taken up by the courts, in particular in special circumstances. Therefore, they are still treated as dies non judicious. Similarly, this period during COVID has to be treated as dies non judicious. That cannot be treated as being normal functioning days of the court. That they have explained in para 25(1) of the judgment. And if Section 4 of the Limitation Act is required, I have quoted it in the presentation, a court shall be deemed to be closed on any day within the meaning of this section if during any part of the normal working hours it remains closed on that day. If during any part of its normal working hours, as you know, that the orders of the Chhattisgarh High Court mentioned that courts will function only between 11 a.m. to 2 p.m. So therefore, the entire day of the court was not available for its functioning. Therefore, even by broad interpretation of Section 4 of the Limitation Act, the courts cannot be treated as having functioned normally during that period. This was the another reason before the Supreme Court to say that yes, the written statement should have been allowed to be filed. Supreme Court also noted that the stay of the suit and the application, the other application, they required immediate consideration. They actually, Supreme Court mentioned particularly about stay application, stay of the suit, the application for stay of the suit under section 10 of the CPC. And they said, on one hand, you are adjourning the application for stay of the suit, and on the other hand, you are almost punishing the defendant for not filing a written statement. And they said that the procedural rules and the substantive law, there is a difference. The rules of procedure have to subserve, have to actually be used for substantial justice, and they cannot be used for punishing the parties. And finally, the appeal was allowed. The notarized written statement, which was notarized in July, that was taken on record, and the court was directed to proceed further after taking this on record, and pending applications to be taken before any other step. Now, as I told you that it is not directly on IBC, but there are very important implications. You see that demand notice was given on 1st of July 2020. 10 days thereafter, the application under section 9 could be filed, as far as section 9 is concerned. This is my own, you can say, analysis or comment on the entire issue. But the reply came on 13th of July. Had the party been ready on 10th or 11th, and application could have been filed, the other party would have lost a chance to claim that the debt is disputed. There is a dispute. Secondly, had the other party been vigilant, they should have actually sent the reply within 10 days. So the learning from this case, one learning from this case is that there should not be any delay. It can be very costly. So far, the case has not proceeded, but I am talking on academic ground, academic lines, that the demand once made must be followed up very strictly according to the schedule, so as not to allow the other party to misuse the period after 10 days. And if there is a genuine dispute, then it should not be kept pending. The reply must be given within 10 days, lest even a genuine dispute is discarded while taking up the matter under section 9 of the IBC. Secondly, as I told you, limitation and condonation of delay needs to be distinguished. Thirdly, there is a stay of suit application, and on the other hand, there is a provision for moratorium under section 14. As far as moratorium is concerned, a specific order has to be passed by the NCLT. Unless the adjudicating authority passes that order, moratorium doesn't take effect. And stay of suit can be ordered by the civil court as per its own discretion. Although I have my own reservation in this particular case, whether stay of the suit will be ordered or not, because stay of the suit under section 10 can be ordered only when there is another suit pending. In this case, there is no suit pending. It is an application pending under section 9 of the IPC. This is not the same thing as the suit. Nevertheless, whatever decision that happens, but I mean to say, these two things must be distinguished and clearly understood. I think I have finished. And if there are any questions, Ms. Sharma, in case you can invite questions.
If anybody has any questions, please ask from the faculty.
Can I stop sharing this?
Yes, sir, you can. Thank you so much, sir, for the session. It was very detailed and informative. Thank you for giving your time and taking the session. Thank you. And thank you so much to all the participants also.
Thank you.
Thank you.
Thank you. Can I disconnect, ma'am? Any no
Yes,
questions?
yes, sir. Yes, sir. Yes, sir.
Thank you, ma'am. Thank you.